I request Geeta Shreya, a student of third year BA LLB, to deliver the welcome address.
A very good afternoon to one and all present here. I welcome all of you for today's session on the Cabinet Government. I, Geeta Shreya, on behalf of CMI University School of Legal Studies, extend a hearty welcome to our eminent speaker for the day, Mr. V. Sudish Pai, a distinguished lawyer and an acclaimed author specialized in constitutional law and administrative law. Having obtained a master's in mathematics from Loyola College, Madras, and a degree in law from University Law College, Bangalore, with the highest marks in the university in constitutional law and administrative law, he also started the general practice of law over 36 years ago and joined the chambers of the Doyen of the Bar, late Shri S.G. Sundaraswamy, renowned senior advocate and former Advocate General Karnataka. Mr. V. Sudish Pai assisted Dr. Durga Das Basu, the world-renowned commentator on constitutional law, in the revision of his commentary on the Constitution from 1993 to 1997. He was also a government advocate of High Court of Karnataka from 1999 to 2006 and is a contributor to the Restatement of Indian Law on Legislative Privileges. He has been a visiting chair professor of Ashutosh Mukherjee Chair at the West Bengal National University of Judicial Sciences, Calcutta, and he is also a resource person at the National Judicial Academy, Bhopal, for continuing legal education for judges. His contribution to academics, particularly in the area of critical constitutional analysis, has been substantial and significant. I would like to quote from Chief Justice Venkatachalai's foreword to Shri Sudish Pai's latest book, Constitutional Supremacy, A Revisit. CY took upon himself this enormous task of educating the school men of the spirit of constitutionalism. CY's work is monumental. Sudish Pai, an accomplished lawyer and jurist, belong to the same distinguished class. Unquote. Sir, we are eagerly waiting to listen from you. I once again welcome our guest speaker and all the participants. Thank you.
Thank you, Shreya. Sir, I request you to take over.
Good afternoon to all of you. I'm indeed very happy to join in this webinar and share with you some thoughts on a topic of vital significance and interest in our polity, in our constitutional scheme, namely cabinet government. The Constitution has adopted the cabinet form of representative democratic government as in the United Kingdom. It's a form of government tersely described as based on the Westminster model, which is a constitutional monarchy where the king reigns but does not rule, and his relations with the ministry headed by the Prime Minister are governed by well-recognized conventions. The Indian Constitution declares that there shall be a president and all the executive power of the Union is vested in the president. The President of India is the head of state. He represents the nation. He is conferred with a large repository of powers. All actions are taken in his name. What is true of the president at the center is generally true of governors at the level of the state. Article 52 and 53 and Articles 153 and 154 with regard to governors in the state codify this. The executive power of this union is vested in the president. The executive power of the states is vested in the governors. Executive power is the residue after the exercise of legislative and judicial power. It has been very succinctly delineated in the Supreme Court judgment in Ram Javaya's case in 1955. So the Constitution enumerates a melange of powers for the presidents and the president and the governors. Executive power is vested in them. That is the power of clemency or pardon, appointment of ministers, appointment to the Attorney General or the Advocate General, conduct of business. The president or the governor is a part of the legislature at the union or the state level. The summoning, prorogation, and dissolution of the houses of parliament or the state legislature is also by the president or the governor. They have the power to address and send messages as also special address. Disqualification of legislators is decided by the president, of course, on the advice of the Election Commission. Assent to bills. Before a bill that is enacted by the legislature becomes a law, it is required to be assented by the president or the governor. Moving financial bills, recommendations of the president. Ordinance making power, appointment of judges of the superior judiciary, the Supreme Court and the High Courts, seeking the advisory opinion of the Supreme Court, appointment of the Comptroller and Auditor General, appointment of governors in the states, appointment of the Finance Commission. Previous sanction of the president is required in matters where a law imposes restrictions on interstate trade or commerce. Appointment of civil servants, Public Service Commission, Election Commission, proclamation of emergency, failure of constitutional machinery, financial emergency, assent to constitutional amendment. Such a wide and impressive range. What do you not have? All this is quite impressive. As Dicey says in his Law of the Constitution, referring to Blackstone's commentaries, talking of the sovereign and the royal prerogative. And he says it is but one fault. The statements it contains are the direct opposite of the truth. The executive power in England is in fact placed in the hands of a committee called the Cabinet. If there be one person in whose single hands the power of the state is placed, that person is not the sovereign, but the Prime Minister. That is so in India too. The truth is that the president or the governor is only a metaphor for the Council of Ministers on whose advice alone they can act, except in very narrow areas clearly defined and confined. Articles 74 and 163. The machinery of government set up by the Constitution follows in all essentials the British model, the Westminster form of government. Not the Potomac, but the Thames fertilizes the flow of the Yamuna, if we may adopt a riverine imagery. Observed Justice Krishna Iyer very picturesquely in the famous Samsher Singh case, bringing out the essence of our system of government, which is, as I said, the cabinet form of government based on the Westminster model. Now, Articles 74, 75, 77, and 78 regarding the Union, and Articles 163, 164, 166, and 167 at the level of the states capture and embody the essence and nuances of the parliamentary system. This is succinctly expressed in Chief Justice B.K. Mukherjee's judgment in Ram Javaya's case, 1955 Supreme Court 549. And I quote, "Our constitution, though federal in its structure, is modeled on the British parliamentary system. The president is the formal or constitutional head of the executive. The real executive powers are vested in the ministry. We have the same system of parliamentary executive as in England, and the Council of Ministers, consisting as it does of the members of the legislature, is like the British cabinet, a hyphen which joins, a buckle which fastens the legislative part of the state to the executive part. The cabinet, enjoying as it does the majority in the legislature, concentrates in itself the virtual control of both legislative and executive functions. And as the ministers constituting the cabinet are presumably agreed on fundamentals and act on the principle of collective responsibility, the most important questions of policy are all formulated by them." Unquote. Now, the basic tenets of a parliamentary system or a cabinet form of government are the primacy of the prime minister, the accountability of the government, that is the executive branch, to the lower house, the popularly elected house of the legislature, and collective responsibility. Now, it's well settled that parliamentary system of government is not government by parliament. It is government by cabinet, subject to control and criticism of parliament. Indeed, Ilbert, an authority on parliamentary system, in his book Parliament, remarks that the cabinet legislates with the advice and consent of the president. The position of the prime minister in the scheme of things is very vividly put. Ernest Barker, one of the political scientists, says the cabinet is the core of the British constitutional system. It's the supreme directing authority, the magnet of policy, which coordinates and controls the whole executive government and integrates and guides the work of legislation. In a parliamentary system based on the Westminster model, the cabinet is the keystone of the political arch. The prime minister is the keystone of the cabinet arch. However, Ivor Jennings, an authority on constitutional law, said that it will be more accurate to describe him, that is the prime minister, as the keystone of the constitution, which is as precise a definition as it is picturesque. It is said the prime minister is central to the formation of the cabinet, central to its life, and central to its death. The government is the master of the country. The prime minister is the master of the government. He is the focal point of public attention and governmental power. Bejour, in his constitution, said that the cabinet is a hyphen which joins, a buckle which fastens the legislative part of the state to the executive. This is what was referred to in Ram Javaya's case by Justice Mukherjee. But Crossman, in his introduction to the latest edition of Bejour, says, emphasizing the growing importance of the institution of the prime minister, that the hyphen which joins and the buckle which fastens is one single man, namely the prime minister. That sums up the preeminent position of the prime minister in the cabinet governmental setup. His primacy is beyond doubt. It is the prime minister who rules and governs. The president, like the crown in the UK, is only a nominal ceremonial head who represents the nation. The position of the governors in the states is no different, except as regards matters which a governor has to exercise in his discretion. That area of discretion is clearly defined and confined by the Constitution itself. Any reference to the president will mean and include reference to the governor, and the prime minister would also mean the chief ministers. Now, the constitutional position regarding the exercise of powers by the president and the governor is settled and clear. They have to exercise their powers and discharge their functions on the basis of ministerial advice. It is well established that the position of the president and the governor is akin to that of the monarch in Britain. He is generally bound by the advice of the ministers, except where it is otherwise prescribed constitutionally. He can do nothing contrary to their advice, nor can he do anything without their advice. Indeed, if you go back to the Constituent Assembly debates, moving the draft constitution on the 4th of November 1948, Dr. Ambedkar posed this question in the Constituent Assembly as to what is the form of government that the Constitution envisages and what is the form of the Constitution. And he proceeded to state, I quote, "There is placed at the head of the Indian Union a functionary who is called the President of India. The title of this functionary reminds one of the President of the United States, but beyond identity of names, there is nothing common between the form of government prevalent in America and the form of government proposed under the draft constitution. The American form of government is called the presidential system. What this constitution proposes is the parliamentary system. The two are fundamentally different. Under the draft constitution, the president occupies the same position as the king under the English constitution. He is the head of the state, but not of the executive. He represents the nation, but does not rule. He is the symbol of the nation. His place in the administration is that of a ceremonial device on a seal by which the nation's decisions are made known. The President of the United States is not bound to accept the advice tendered to him by any of his secretaries. That is the ministers of his cabinet. The President of the Indian Union will be generally bound by the advice of the ministers. He can do nothing contrary to their advice, nor can he do anything without their advice." And he went on to say, if there is any office under the Constitution of India comparable to the US President, it is the Prime Minister. On the debates on Article 74, which is the focal point of the cabinet form of government, it was stated in the Constituent Assembly, these articles should not be interpreted literally because they embody conventions of the cabinet system of government evolved in Great Britain as a result of a long struggle between the king and parliament. Therefore, it is said that there shall be a council of ministers with the prime minister at the head to aid and advise the president in the exercise of his functions. That does not mean, please mark these words, that does not mean that normally the function of the prime minister is to aid and advise the president in the exercise of his functions. In fact, the position is altogether opposite or the reverse. It is the prime minister's business with the support of the council of ministers to rule the country, and the president may be permitted now and then to aid and advise the council of ministers. Therefore, we should look at the substance and not at the mere phraseology, which is a result of conventions. This is what the Constituent Assembly very emphatically said. Article 74 is all pervasive. Article 74, which says that there shall be a council of ministers headed by the prime minister to aid and advise the president in the discharge of his functions, is all pervasive and does not make any distinction between one function and another. As the Supreme Court observed in UNR Rao versus Indira Gandhi, 1971, we must remember it is interpreting a constitution establishing a parliamentary system of government with a cabinet. In trying to understand this, one may well keep in mind the conventions prevalent at the time the constitution was framed. Indeed, there is no case which can arise where the president will be called upon to discharge his functions without the aid and advice of the Prime Minister and the Cabinet. Under a parliamentary system of government, there are only two prerogatives. This is what Dr. Ambedkar said. There are only two prerogatives which the head of state may exercise. One is the appointment of the Prime Minister. The other is the dissolution of Parliament. The position of the governor is exactly the same. However, Article 163, which says that at the level of the state, there shall be a council of ministers to aid and advise the governor on whose advice he shall act, makes a slight difference in the position of the governor. He is not bound by the advice of the ministers in matters where he is by or under the constitution to act in his discretion. The discretionary power of the governor is restricted by the express language of Article 163, which does not confer on the governor any general discretionary power to act against or without the advice of the Council of Ministers. The exposition in the Constituent Assembly debates about this is very clear. Indeed, speaking on draft Article 143, which is the present Article 163, Sir Radhakrishna Swamy, one of the principal architects of the Constitution and one of India's most preeminent constitutional lawyers, said that in the first place, the general principle is laid down in Article 143, namely the principle of ministerial responsibility, that the governor in the various spheres of executive activity should act on the advice of the ministers. Certain specific functions are to be exercised in his discretion as expressly provided in some articles. The article will have to be read in conjunction with those other articles which specifically reserve the power to the governor. It is not a general clause having regard. It's not a general clause giving the governor power to disregard the advice of the Council of Ministers in any matter in which he finds he ought to disregard. Those functions are specific, which he is specifically required to be exercised by him in his discretion, are specified by the Constitution itself. Articles 239(2), 371 capital A, 2B and D and F, para 9(2) of the 6th schedule. These are some of them. The position that in the discharge of their functions, the president and governors have a discretion to disregard the advice of the Council of Ministers is inconsistent with the express conferment of discretionary power on the governors under Article 163, Subarticle 2. For if the governors have a discretion in all matters under 163(1), it would be unnecessary to confer on them an express power to act in the discretion in a few specified matters. That itself negatives the view that the president and the governor has general discretionary power to act against ministerial advice. The area of discretion is clearly confined and defined. The only functions which the head of state can, as per settled constitutional law and convention, exercise in his discretion is, as already stated, appointment of the Prime Minister or the Chief Minister, dismissal of the government which has lost majority in the House but refuses to quit, dissolution of the lower house, granting sanction to prosecute a minister, and in the case of a governor, a report under Article 356 regarding failure of constitutional machinery in the state, apart from those which are expressly conferred by the Constitution. For example, 103 and 192 regarding disqualification of members of Parliament or the state legislature, which the head of state is to decide according to the opinion given by the Election Commission and not the Cabinet. That's what the Constitution expressly provides for. Now, this does not reduce the head of state to a mere figurehead or a rubber stamp. He still has the right to be consulted, the right to encourage, and the right to warn. The right to offer on his own initiative suggestions and advice to the ministers, even where he is obliged in the last resort to accept the formal advice tendered by the cabinet. Acting on ministerial advice does not necessarily mean immediate acceptance of the ministry's first proposals. He can state his objections to any proposal and ask the ministers, if necessary, to reconsider it. It is only in the last resort he must accept their final advice and act accordingly. This principle and the right of the head of state to influence the Council of Ministers is embodied in Articles 74(1) read with 78 and 163(1) read with 167 at the state level. Now, the purport of all this, what I have stated so far, is clear from a beautiful passage in the memorandum submitted by the then Prime Minister Asquith to King George V more than 100 years ago in 1913, and expressed quite tersely and precisely. This is what the Prime Minister said. A constitutional monarch in this country is entitled and bound to give his ministers all relevant information which comes to him, to point out objections which seem to him valid against the course which they advise, to suggest, if he thinks fit, an alternative policy. Such instructions are always received by the ministers with utmost respect and considered with more respect and deference than if they proceeded from any other quarters. But in the end, the sovereign always acts upon the advice which the ministers, after full deliberation, and if need be reconsideration, feel it their duty to offer. They give that advice, well knowing that they can and probably will be called upon to account for it in Parliament. This memorandum has been quoted in the Constituent Assembly debates. These conventions have been adverted to, reiterated, and accepted by the Supreme Court as part of our constitutional law in a number of Constitution Bench decisions, and hence these are legally enforceable. In fact, the 20th report of the Governors Committee also said the same, that I don't want to quote here. The substance of it is that the governor is bound to act on the advice of the Council of Ministers, though of course he can refer it to them for reconsideration. Now, Sirvai, one of our most outstanding constitutional lawyers, points out in his constitutional law, magnum opus, and says, it is enough to say that Samsher Singh's case, that is 1974, a 7-judge bench decision, AR 74, Supreme Court 2192, has finally established, and it is submitted rightly, that the President is the constitutional head of government obliged to act on the advice of his Council of Ministers. Now, Samsher Singh was referred to a larger bench to delineate the constitutional position of the President and the Governor. That reference was necessitated by a couple of earlier rulings, which really represented a drift and not the trend of judicial opinion in that behalf. The issue was whether the constitutional requirement of the satisfaction of the President or the Governor means his personal satisfaction. This was what was discussed and decided. Of course, right from the beginning, right from the time the Constitution was framed, there was no doubt about what this means. But there were a couple of rulings, one of them, Jyoti Prakash Mitta, regarding the determination of the age of a High Court judge, a Calcutta High Court judge, and one or two other cases where the Supreme Court took a somewhat different, and if one may say so, a mistaken view of the whole concept. In Samsher Singh, the court unequivocally reiterated that the settled legal position that the President or the Governor is only the constitutional head, the real power being vested in the Council of Ministers, on whose aid and advice the President exercises his powers and functions. president and the governor. The satisfaction required by the Constitution is not the personal satisfaction of the president or governor, but please mark these words, this is the substance of the whole thing, but the satisfaction of the president or governor in the constitutional sense, in the cabinet system of government, that is the satisfaction of his council of ministers. In constitutional law, the functions of the president and the governor and the business of government belong to the ministers and not to the head of state. That aid and advice of ministers are terms of art, which in law mean, in the cabinet context of our constitutional scheme, that the aider acts, the advisor decides in his own authority and not subject to the power of the president to accept or reject such action or decision, except in the case of governors to the limited extent that Article 163 permits, and its discretion remote control by the center has play. Justice Krishnaya, in his concurring judgment, put it in his inimitable style in some shade saying, the omnipotence of the president and the governor at the state level is euphemistically inscribed in the pages of a fundamental law with the obvious intent that even where express conferment of power and functions is written into the articles, such business has to be disposed of decisively by the ministry answerable to the legislature and through it vicariously to the people. This is the whole cornerstone of a democratic representative government that our constitution embodies. That all business has to be disposed of decisively by the ministry, answerable to the legislature, and through it vicariously to the people. Thus, vindicating our democracy instead of surrendering it to a single summit soul whose deification that is incompatible with the basics of our political architecture. This underscores the ideas of representation and responsibility, the twin attributes of a parliamentary system of government. It has been stated that Article 74 is all pervasive in its character. This arose in the debates in the Constituent Assembly, later in the early years of the Constitution when there was a difference of opinion between the first president and the first prime minister on matters regarding the Hindu Code Bill, and President Rajendra Prasad, who himself was the person who presided over the Constituent Assembly debates as the president of the Constituent Assembly, had his doubts, and the matter was referred for opinion to two preeminent lawyers, Sir Aladi Krishnaswamy, one of the architects of the Constitution, and as I said, one of India's greatest constitutional lawyers. In fact, it has been said of him that even in the 1920s and 30s, he knew all the constitutional law, not only of India, when constitutional law practice was not in vogue. It did not give you bread, leave alone butter. And India's first Attorney General, Settleward, and the opinion was uniform that the president is bound to act on the aid and advice of the cabinet headed by the prime minister. Article 74 is all pervasive in its character, does not make any distinction between one kind of function or another. It applies to every function and power vested in the president, whether it relates to addressing the House or returning a bill for reconsideration or assenting or withholding assent. The expression aid and advice in Article 74 cannot be construed so as to enable the president to act independently or against the advice of the cabinet. In Article 111, dealing with the power to remit a bill for reconsideration, the president, it was said, the president is not intended to be a revisional or appellate authority over the cabinet. A bill might have been introduced either by a private member or by a minister. It may be rushed through in parliament. The cabinet may notice an obvious slip or error after it has passed the houses. The power vested in the president is as much intended to be exercised on the advice of the Council of Ministers as any other power. Now, all this has been referred to in great detail and approved by the Supreme Court in some Shri Singh case. And it has been stated, now this is the declaration of law. We declare the law of this branch of our Constitution to be that the President and Governor, custodians of all executive and other powers under various articles, shall, by virtue of those provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional situations. This, in such clear terms, unequivocally delineates the constitutional position. It is said the Prime Minister is the keystone of the political arch in the cabinet form of government. It is the Prime Minister through whom accountability and collective responsibility are enforced, because these are the twin attributes of a cabinet government. The Prime Minister's functions and powers are wide and varied. His position rests on his leadership of the government in Parliament and the ruling party, and is being the main channel of communication between the head of the state with the head of the state. His control of the cabinet in selecting ministers, assigning them portfolios, and even compelling them to resign, in setting the agenda for cabinet meetings and taking decisions. He decides and seeks dissolution of the lower house of Parliament and a fresh mandate. In fact, some critics have rightly said that what obtains is not so much a cabinet system, but a system of prime ministerial government. If the cabinet discusses anything, it is the Prime Minister who decides what the collective view of cabinet is. No minister could make a really important move without consulting the Prime Minister. And if the Prime Minister wanted to take a certain step, the minister concerned would have to agree, argue it out in cabinet, or resign. A minister has no place in the cabinet if his thoughts and ideas are not in consonance with that of the Prime Minister. There is no better delineation of the Prime Minister's position than what Sir Ivor Jennings, an authority on cabinet government, says in his book, Cabinet Government. Given a solid party backing and confidence among party leaders, a Prime Minister wields an authority that a Roman emperor might envy, a modern dictator strive in vain to emulate. It is said he has even the power of destroying his creator, the House of Commons. For if the government is defeated in the House, he can, instead of resigning, advise the monarch to dissolve the House and go for a fresh election. The position is, however, slightly different under the Indian Constitution, in that the president must explore the possibility of having an alternative government in place. And if that is not found feasible, then dissolve the House and set in process a motion of seeking a fresh mandate. Dissolution of the House is said to be a power in the hands of the Prime Minister to appeal from the legal to the political sovereign. Now, apart from being fortified in by these conventions of government, about the parliamentary system of government, the office of the Prime Minister, it has been formally mentioned in the Constitution, which expressly states that the Prime Minister shall be the head of the Council of Ministers. In fact, Dr. Ambedkar, speaking in the Constituent Assembly, emphasized the concept of collective responsibility as an overarching principle of the parliamentary system, and said the Prime Minister is the only sanction through which collective responsibility could be enforced. And that requires two principles, enforcement of two principles. No person be nominated to the cabinet except on the advice of the Prime Minister, and no person be retained as a minister if the Prime Minister wanted him to be out. The Constitution just recognizes the pivotal position of the Prime Minister. It is important to note that a cabinet enters office and goes out of office with the Prime Minister. A change of the Prime Minister, be it by resignation or death, entails a change of the cabinet. It has been rightly said that while the party system gives the cabinet its homogeneity, the position of the Prime Minister gives it solidarity. The Prime Minister is the leader of the nation and its voice, and its major task is to formulate the policy and coordinate the working of the government. The Constitution Bench decision in Manoj Narula, 2014, lays down the correct legal position in this behalf. It has been said that the choice of who should be appointed to the Council of Ministers is entirely with the Prime Minister or the Chief Minister in the case of a state. No directions can be issued in that regard. It is a legitimate constitutional expectation that the Prime Minister would choose appropriate persons. But that is not a matter that is justiciable. While interpreting Article 75(1), a disqualification cannot be added by judicial interpretation. It is legitimately expected the Prime Minister, living up to the trust reposed in him, would not choose people with criminal antecedents. This is what the Constitution suggests. This is the expectation. The rest is left to his wisdom. This is what the Supreme Court said, and if I may say so, with respect, very rightly. Now, similar to the preeminent position of the Prime Minister in the parliamentary system, another essential feature is the accountability of the government, the executive branch, to the legislative. That is the lower house, the popular house, elected house. It is implicit in this requirement the Prime Minister must be a member of the lower house, the Lok Sabha. However, there is some difficulty here. With utmost respect, I would submit that there are Supreme Court decisions which have not taken a correct view in perspective, and I would think they're essentially erroneous. The Supreme Court in S.P. Anand versus Devegowda and Janakraj Jai versus Devegowda held that a person not being a member of either house can be appointed Prime Minister, and he could be elected to Parliament within 6 months. It did not consider it mandatory that the Prime Minister must be a member of the lower house. Now, these decisions were rendered on the basis of the language of Article 75(5). Article 75(5) and the corresponding article in the matter of states permits a person to be a minister, a member of the Council of Ministers, for 6 months, and it is enough if he gets elected to either House of Parliament within a period of 6 months of his being sworn in as a minister. And a minister could be a member of either house. Now, this was the rationale on which the court proceeded. But I would respectfully submit that the court missed that there is a distinction, not just a distinction, a very, very vital distinction between a Prime Minister and any other minister. Article 75(5) treats all ministers alike, but the judgment misses to notice the preeminent position of the Prime Minister in the scheme of our Constitution. All ministers are appointed on the advice of the Prime Minister. With the Prime Minister's departure, either by resignation or death, the entire ministry goes out of office. That never happens if any other minister goes, dies, resigns, or whatever, or dismissed. The Prime Minister is central to the life of the cabinet. Hence, the ministry enjoying the confidence of the majority of the House would have necessarily to mean the Prime Minister commanding such a majority. It is inconceivable the Prime Minister can enjoy the majority, the confidence of the majority, without being a member himself. There may perhaps be some difference in the position of the chief ministers, because you have the concept of a president's rule in the states, but there is no such thing at the center. These issues cannot be decided on the plain language without a reference to an understanding of the conventions underlying the constitutional provisions, as the Constitution Bench pointed out in UNR Rao versus Indira Gandhi. Furthermore, very importantly, These two decisions in Devegowda's case were rendered by a two-judge bench. Matters of such great moment were not referred to and decided by a constitution bench. And these decisions indeed fall foul of Article 145(3). The constitutional requirement is that the government is responsible to the legislature and must enjoy the confidence of the majority of the House. The crucial question then remains, what is the test of majority and how is it to be determined? Of course, it is one aspect of it is to be determined only on the floor of the House and nowhere else. Now, when a party or a combination of parties, an alliance of parties has the requisite number to constitute a majority, the position is simple. The government headed by the leader of such a party or alliance is to be installed as the Prime Minister. If, however, there is some uncertainty about the numbers supporting such a leader who appears capable of forming a government, the President may swear him in as Prime Minister and require that he seeks a vote of confidence to establish his majority within a specified period. That is quite legitimate and required. But the Supreme Court has held, and rightly, with reference to such directions, the Constitution bench in Harsharan Verma versus Charan Singh, the Constitution knows of no such hybrid thing as a Prime Minister subject to a condition of defeasance. Conditions like the Prime Minister seeking a vote within a particular time imposed by the President may create considerations of political morality or conventional propriety, not of constitutional validity. Once a government takes office, it is important to note the government being responsible to the legislature and enjoying the confidence of the House need not be on a minute-to-minute basis. Minority governments are not unknown or impermissible. When a government is in office or has won the confidence vote, then the responsibility to the House, that question of enjoying the majority support, is between the government and the lower house. The President has no place in that scheme of things. Thereafter, the President asking the Prime Minister to seek a vote of confidence is wholly unnecessary and even improper. It is politically wrong, legally untenable. It eats into the vitals of the functioning of a parliamentary democracy. The annual budget presented and passed in the House is perhaps the most emphatic expression of confidence of the House in the government. It is well settled that defeat of every motion or even a bill does not require resignation of the government. It is only when a motion of no confidence is passed or when a finance bill or any measure involving substantial issues of governmental policy is defeated that the government has to resign. If it is felt that the government does not enjoy the confidence of the House, it is for the opposition to move a no confidence motion and unseat the government by successfully carrying that motion. Implicit in these well-established conventions is the idea that minority governments can function. A government need not be seen or shown to enjoy the confidence of the majority of the House every moment on every issue. No day-to-day presidential surveillance of this is contemplated or warranted. The President is not to act like the opposition and require the Prime Minister to seek and win a vote of confidence. Any such directions by the President in such circumstances, being clearly unconstitutional, are liable to be ignored. The constitutional role and position of the head of state cannot be converted to that of the opposition. Otherwise, the whole concept of our parliamentary democracy, based on a Westminster model, will run the risk of being perverted. The nuances of parliamentary democracy, we must remember, are political. The responsibility of government to parliament is a political relationship. As such, it is not a matter of precise definition, and lawyers must resist the temptation to lay down rules for it. Of course, I am reminded of the classic instance when in 1999, the lone ADMK member withdrew support to the NDA government headed by Atal Bihari Vajpayee. President Narayanan wanted him to seek a vote of confidence. I would submit it was a wholly wrong proposition. Parliament was in session, the budget was presented, and if the budget was passed, there was no clearer and a more emphatic vote of confidence in the ministry. The president asking the prime minister to seek a vote of confidence in such circumstances was politically wrong, constitutionally untenable. I would think the prime minister should have rejected such suggestion, because this undermines the very basis of the parliamentary system. The system cannot be allowed to suffer a loss of identity. The president has the right to be consulted, the right to encourage, and the right to warn. And these conventional rights of being adequately kept informed are given constitutional recognition in Article 78 and 167. But they cannot extend to the president's active participation in the governance of the country. It is the prime minister and the government alone that is to govern. Any inroad into this is not good for the health of the system. Nightfall does not come at once, nor does breakdown of systems. In both cases, there is a twilight when everything remains seemingly unchanged. And it is at such times we have to be aware of change in the air, however slight, lest we become victims of the imperceptible change. Another equally fundamental feature of the parliamentary system is the collective responsibility of the Council of Ministers for all actions of the government. It has been very beautifully equipped. It matters not what we say, but we must all say the same. That's the whole thrust of a cabinet government. The concept of collective responsibility predicates loyalty, solidarity. The government as a whole must resign if defeated. Government business is confidential, and it protects the personal responsibility. Now, this collective responsibility has been very beautifully put by Lord Salisbury. For all that passes in the cabinet, every member of it who does not resign is absolutely and irretrievably responsible, and has no right afterwards to say that he agreed in one case to a compromise, while in another he was persuaded by his colleagues. It is only on the principle that absolute responsibility is undertaken by every member of the cabinet who, after a decision is arrived at, remains a member, that the joint responsibility of members to parliament can be upheld, and one of the most essential principles of parliamentary responsibility established. Dr. Ambedkar also emphasized the need and importance of this collective responsibility in the Constituent Assembly debates. Now, in India, this is recognized and codified in Article 75(3) and 164(2), which lay down the ministry shall be collectively responsible to the lower house. And as regards the individual responsibility of a minister, it would be directly enforced. Article 75(2) and 164(1), which envisage that a minister holds office during the pleasure of the president, because the pleasure of the president is the pleasure of the prime minister. This is one of the foundational features of the working of a cabinet in the parliamentary form of government. Now, Articles 77 and 166 deal with conduct of business. The rules of business are framed for the more convenient transaction of the government's business. The scheme of these articles is for the purpose of discharging executive functions. But the Council of Ministers is collectively responsible to the legislature. The rules lay down how matters are to be dealt with and by whom, and how decisions are to be taken. They also speak of collective responsibility. In fact, quite a few constitution bench decisions have reiterated this. You have Bachitar Singh in 1963, where the constitution bench noted the concept of collective responsibility as also the primacy of the chief minister. That was a matter concerning the state of Punjab. Primacy of the chief minister in the scheme of things, and rules in the regard, and that held that an order passed by the chief minister, even though on a matter pertaining to a portfolio of another minister, would be deemed to be the order of the Council of Ministers. And it would be the chief minister's advice to the governor, for which the Council of Ministers is collectively responsible. In Sanjeevi Naidu versus State of Madras, another constitution bench stated, the governor was authorized to make rules for more convenient transaction of government business. That is the very essence of joint responsibility, that every individual minister and the cabinet is responsible to the legislature for all actions taken by the ministry. Of course, this responsibility is political and not personal. Now, as we know, all these powers, various powers of the president or the governor are exercised only on the advice of the Council of Ministers. All constitutional functions, like imposition of president's rule, emergency, removal of governors, grant of pardon, to mention a few, are all exercised on cabinet advice. The president or the governor is the sole judge of the sufficiency of facts and propriety of the action. Yet, while the advice is constitutionally immune from scrutiny, the material which formed the basis is open to examination, whether such material was relevant and was such that on its basis a reasonable person could arrive at that conclusion. It is to be examined whether the facts were verified and bona fide. The governor's report and the president's action, in the case of Article 356, legal malafides, irrationality, extraneous considerations, are all grounds of challenge of a presidential proclamation. The doctrine of pleasure has been hedged in by constitutional limitations. It is not a license to act arbitrarily. Discretion conferred on a public authority, though in terms absolute, will necessarily have to be exercised reasonably for public good. The distinction between need for a cause and the need to disclose a cause is important and has been adverted to by the Supreme Court in a number of decisions. Judicial scrutiny is limited to see whether the reasons bear rational nexus to the action. Absence of reasons or bad reasons can destroy a possible nexus and vitiate the order on the ground of malafidis. Now, even in the matter of appointment of government and appointment of judges, judicial scrutiny is limited to the question of eligibility, not suitability. It's only a writ of quo warranto that would be available. Now, assent or non-assent to bills is another very crucial area. And I would submit, of course, that would take by itself another subject for another talk, is justiciable, though maybe to some limited extent. James Madison, one of the framers of the American Constitution, said in the Federalist, "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed. The next place oblige it to control itself. A dependence on the people is no doubt the primary control on government, but experience has taught mankind the necessity of auxiliary precautions." Now, judicial review is one such auxiliary precaution. Now, in the end, as that great Prime Minister, the Earl of Oxford Asquith, said, in the ultimate analysis, a Prime Minister, the position and power that he enjoys depends on his personality. The office of the Prime Minister is what its holder chooses to make of it. And as regards the President, I would just tell you this and then call it a day. How a President, as the constitutional head of state, must express his disapproval of any governmental action was answered by a former Chief Justice of Pakistan in the context of whether the President could refuse assent to a bill validly passed by the Assembly when Pakistan had a constitution like ours and was experimenting democracy. Justice Munir said something like this: "If you think it is a matter of great importance and you cannot in all conscience accept the measure presented to you, you can and you must, if you're true to your oath, refuse to assent. But having refused, you must then resign. The system must go on. The people will know you have resigned and why, and will sort out things within their government." This, in a sense, delineates the position and functioning of the president and the governors vis-a-vis the prime minister, the chief ministers. It will all depend in one sense upon the personality of the occupants of that exalted office. Thank you very much for your patience and courtesy.
I would now request Chinmaya of class 4th year BALB to deliver the vote of thanks.
Thank you so much, Vibha, and good afternoon to one and all present. My name is Chinmaya of 4th year BLLB, and I would like to begin by thanking our advocate and eminent jurist, Sir Sudish Pai, for this incredibly informative session. Thank you so much, sir. And sir threw light on the various nitty-gritties and nuances of constitutional law and the powers and roles that Prime Minister and President has to play in, governing a nation, especially such as the large democracy that is India. Thank you, sir, for the same. I'd also like to thank our esteemed Dean, Dr. Subramanya, sir, our Vice Principal, Professor Pranishwaran, our faculty for organizing this, and also would like to thank my fellow peers and to everyone for making this a great success. Thank you all and have a nice day.
Thank you so much. My special word of thanks to Professor Subramanya, an old friend, philosopher and guide, and to all of you students whose presence enabled me to think once more that I'm young. Thank you.
Thank you so much.
Thank you one and all for your coordination.